Group 6 matter. This is running it before your lordship list for 2 or 3 occasions. The difficulty I'm facing, one of the contempt court has granted us last opportunity to head out the appeal. Lordship, I'm seeking upgradation of the matter. Any day, Monday, any time.
What is the
In some
serial?
section.
What is the serial number?
Alert.
What is the serial number on the list?
Last day before yesterday, item number 43.
43 is
43.
being, the list is being called. The list was being called.
There is a full court reference. My lordship is pleased to take up until 38, 37. 1146.
So it will come anyway on the next day.
Monday.
It
Some
will come.
preference,
We have already taken up to 38. It will come. Don't worry. See on Monday. See the position on Monday. Yes.
May I just record the slip?
No, we are not accepting any slip. You see the position, then maybe. Yes.
Contempt application.
After holidays now.
It will be appear on Monday. It will appear on Monday.
No, sir. You watch the list on Monday, then you mention. Yes.
It's August order.
Maybe. After holidays. Yes.
Item number 1.
She might make you appear on behalf of petition. Lordship, kindly come page 90. Page 19, Lordship. The order of suspension issued on 6th April 2026. Petitioner was...
Which provision? So cause is required to be issued prior to.
No, Lordship, I have find there is no such provision.
There is no such law, sir.
Lordship. Now, Lordship, what I approached the learned administrative tribunal. Lordship, kindly come. There is no problem with this suspension order issued on 6th April. Thereafter, on 14th April, Lordship, kindly come page 20.
What happened?
Charge
Tell us.
was made over to me.
All the more better. Yes. Things are getting better legally.
Lordship.
Yes.
Now, this charge, Lordship, kindly have a look, Lordship. This charge includes focus. That is the whole difficulty.
You go and participate in the inquiry.
Lordship, kindly come page 24. They have issued show cause.
Why not? Who is stopping them?
But that has not been served upon me. That is why
And how you have annexed it? How you have annexed it? That you submitting, not served on me.
Lordship, they handed over a charge.
Forget it. This is nothing.
All the
You
documents.
go and appear before the authorities.
So cause, list of document.
Where is your OA? Where is your OA?
OA is at page 30. Came to learn, Lordship, after getting charged, I have been charge seated. I have been
nothing. Sorry.
Copy of which was never submitted.
I am appearing for the petition, my lord. Before my learned senior friends start making submission, my lord, I have an instruction which I received in the yesterday night, my lord, over telephone. Client instructed us not to proceed with their matter, my lord. They want to obtain no objection from us. That is why, my lord, I'm praying for after vacation and
No,
during the-
1 week. The learned advocate, Mr. Swain.
But in the meantime, they should serve a copy upon me. No.
Let's see what they do. Why are you, give your appearances, the learned advocates representing the
three, item number three, my lord.
Respondent. My lord, I was supposed to file the affidavit in opposition. I prepared it. I could not affirm it. There is a mishap in my family. May
how much time you require
I need 2 weeks time.
on account of personal.
Wait,
Number 4.
I am for the respondent petition.
My lord, I am the petitioner led by Mr. Dhiraj Trivedi, my lord. There was direction by your lordship on the last day. File a supplementary affidavit for there was a delay, counting delay.
A supplementary affidavit
That has been done. That has been done, my lord. Not
for the delay.
My There was a mistake on our part, my lord, to count the delay for filing this. My lord, for that reason, my lord.
Yes, what's the issue? That was the only defect remaining.
Quick was this one.
Yes, sir. What is the issue?
Your lordship kindly come to the memo, my lord. Copy of the appeal, my lord. Already
Apology. My section 5 is there, and Lordship will kindly appreciate that on the last occasion, the report which was there showed that there was an 82 days delay, whereas our application, we have filed a supplementary affidavit which is before my lord. Whereas the delay.
You want to file an opposition to the application? All right. Then proceed with the merit.
My lord, do they want to file any affidavit with regard to the stay application? My lord,
Let
because
us see. If we may ask them, let us see what is the merits of the matter first.
my lord, merits of the matter, my lord, is. My lord, I will be very grateful if my lord fixes up this matter on a particular day, my lord, because as of today, my lord, I am not fully prepared. I am prepared. I know about the facts and
All
everything.
right. So when? Next week? Which day?
My lord, my lord, can it be the week after that? My lord, because
Last week
my lord,
can be. Which date? Give us an agreed date.
My lord, the difficulty is, as I've submitted before my lord, the petitioner's normal retirement will be up this month.
this one, my lord, I as my
So
lord's officer,
only I will
vouch-
paying my lord before that, your lordship.
Yes, my lord.
So this month he is saying only.
I will do it before. Okay.
He is saying this
Last
month.
week, my lord, next week,
Because some yes,
next week,
Monday or Tuesday in the last week.
yes, my lord.
next week not possible. Next week.
My lord,
Next
what
week
has
he is
happened, my lord,
having a
I
difficulty.
tell my lord, what has happened, my lord, all the matters due to the last 2 weeks where there was no adverse order, all the matters now have been postponed to next week, Monday, Tuesday, Wednesday. Now, my lord, if I am held up in some other court, I don't want to cut a.
No, his anxiety is that this month. So this
I
month.
vouch for it before my
So
lord.
therefore, give us some time also. So
Yes,
you
my
do
lord.
it on Monday and Tuesday.
This Monday, Tuesday, lord.
No, the
Yes,
next
my lord, I
Monday,
will,
Tuesday
will.
there.
I
That
have
will be
said,
this month.
I have said Monday week or Tuesday week, my lord, I am there, my lord.
Which date? Monday or Tuesday?
Any day, my lord, as a lordship.
You want to file any opposition?
No, my lord.
If you
No.
want in the next week, you can file it.
Yes, my lord. That
If you want.
I will-
All right. The
I'm grateful for my lord's
Yes.
message. Actually, my lord, last 2 weeks, my lord, the work was derailed, my lord.
Yes.
All the matters have been fixed now on Monday, Tuesday, Wednesday. I'm grateful.
Item number 5.
Mr. Kushal Chatterjee is in code number 6. I am playing for a spot pass over.
Not today, Mr.
My lord,
Sanyal.
can you please
No, I don't believe in this short password. Not today. Everybody has their own business in the court. If you can't do it today, do it tomorrow. Yes.
Item number 6.
My lord, I am appearing on behalf of the respondent.
My lord, this is relating to, my lord, the sanction of family pension. The first wife, first legally married wife.
Claiming.
She claimed, but it was refused.
There is no dispute that she is the first wife, or that is a
There is no
dispute.
dispute.
No dispute. Okay.
At least it appears from the,
From your side, there is no dispute. Yes.
my lord, I say that it is, my lord, it is apparent and evident from the,
That's not what we asked you. We asked you whether your assertion that you are the first wife is disputed or not. So
according
you
to
are
the judgment,
supposed to say that yes, they have disputed it, or you are supposed to say they have
the
not
private
disputed.
respondent, in spite of direction, they have not filed any.
We are again asking you your status as a
According to
first
me,
wife.
there is no dispute.
We are not asking according to you whether there is any dispute regarding your being the first wife.
Yes, my lord, there
There
is
is no dispute.
there is a
that I am the first wife.
All right, then show from the record that there is an admission that you are the first wife
Yes.
by them.
Yes.
By them.
Yes. If you lordship kindly turn to page. Right, excellent. Page 31 of the
Read the relevant portion.
Fine.
What is it? Page
Fine.
31.
Page 31.
What is
It
it?
is the judgment passed in, my lord, 125 application for maintenance filed by the,
We are asking you whether they have disputed that you are first wife or not.
they have no, the husband did not dispute it.
Husband,
Yes. Because husband, my
who
lord,
is the respondent is husband.
respondent, private respondent is the second wife.
So therefore, who is to dispute or not dispute? The
I-
private respondent. Now, whether she has disputed that you are first wife or not, tell us.
My lord, on the record here, she has not.
She has not disputed. If we find that she has disputed on this false submission, we will dismiss. If we find that there is a dispute raised by her and you are responding incorrectly, we will record this, and
Yes.
on this ground alone, we will
But she did not
reject
file-
the application.
She did not file affidavit to dispute that assertion
Where?
before the, on single judge.
This is arising out of the writ court order.
Yes, which court?
Did you make her a party there?
Yes.
She had appeared.
Party.
She had appeared.
She did not file affidavit. She did not appear. She did not
Then if
appear.
she has not appeared, where is the question of disputing?
My lord, she was served copy.
That we are not asking you. You are just unnecessarily procrastinating a simple query. We are asking you whether she disputes your being the first wife or not. You are trying to canvass everything, but you are not responding to the court's query correctly,
My lord, according to me, she
which
did
is not helping you at all.
My lord, according to me,
We are not asking according to you.
she did not.
If she has not appeared, where's the question of disputing? You should have said that she did not appear. You can't say that she did not dispute. At least this much we expect you know. Wasting the court's time. Now proceed.
Page 31. In the middle part, I'm just reading before your lordship. Moreover, during the examination in chief,
You think any fact you can just take like this through the court and it will not be detected?
may I please one line only from the judgment passed
You
in
don't appreciate such response. Beating around the bush. That is not appreciated by any counsel. It will never help you in any case. Now proceed.
Moreover, during the examination in chief, the opposite party admitted that here
opposite party was husband, admitted that he had married again Mira Sapui, that is private respondent here, is his second wife, and that he has a son from the second wife.
So
That is
With-
the admission. and
not
statement.
her admission, sir.
Her, not
You,
her.
you cannot put it in her mouth. You may try very hard, but you cannot do it.
I cannot.
Yes. Now proceed.
Then, my lord, in similar line, my lord, page 32,
All right. So that we are accepting. Now proceed further. So what is your case?
my lord, my writ petition praying for sanction of family pension in my name as the first legally married wife was rejected on the ground that the bank rightly acted in not deciding any disputed question of fact regarding marital status of the parties.
The writ court should have decided.
I'm telling them what is the
Yes.
judgment state.
Yes.
And the writ court also did not decline to decide disputed question of fact regarding marital status of the parties. My lord, the in view of the record already on record, that is the judgment, as I was just placing a few lines from that judgment in part in the proceeding under 125 CRPC, that there was an admission on the part of the husband that the private respondent was his second wife. During the, he married for the second time, the private respondent, during the lifetime of the first wife petitioner. Therefore, there was no scope to hold that there was disputed question of fact. This is my submission, number one. Number two, my lord, according to the provisions in the bank's own regulation, State Bank of India Employees Pension Fund Regulation, the family pension will be payable to the dependent oblique dependents, not the nominee. Here the bank in the affidavit in opposition said that as per extant rules, the husband during his lifetime at the time of retirement from service submitted and filled up a prescribed format showing and recording the name of the private respondent as his wife and as nominee. Because there is no rule provided in the pension rules for making nomination for pension, family pension, therefore that was not possible or that was not permissible. Now, the rules said, I am handing up before lordships. Rule 23(7)(b).
Yes, which provision?
My lord, Rule 23, it starts from page 8, internal page 8. Pagination is at the bottom of each and every page. Rule 23 starts from page 8. Now I am relying on 23(7)(b) at page 12. At page 12. In the event of death of a member, while in service of the bank after completion of pensionable service for 1 year, or after retirement, B, after retirement, the trustee may sanction family pension to the dependents of the employee on the terms and conditions approved by the central board. Therefore, the nominee is, my lord, excluded. Nominee is excluded. It is the dependent only who may be sanctioned family pension. The bank heavily relied upon that since the private respondent was recorded in the retirement pension documents as his wife and nominee, therefore they have nothing to do with this, and they had to sanction the family pension in the name of the nominee, that is the second wife. But nominee has been, by this clause, by 23(7)(b), has been excluded from being from having any right to be sanctioned the family pension. Moreover, my lord, I have got another submission that the family pension after the death of the employee is not the estate of the employee. He cannot, by way of making nomination or by any testamentary device, make an arrangement for sanction of the family pension to his nominee or the beneficiary in the testamentary device. He has no right, title, interest over the family pension. My lord, the Honorable Apex Court, my lord, held that the employee has no title nor any control over the family pension, as he is not required to make any contribution to it. The family pension scheme is in the nature of welfare scheme. Therefore, it does not form part of the estate, enabling him to dispose of the same by testamentary disposition. My lord, may I end up a judgment, my lord, of Honorable Apex Court? Paragraph 4 and 6. Paragraph 4 and 6 of the judgment, 1991, volume 1, SCC, page 725. Page 725, para 4 and 6. 4, mainly para 4. Paragraph 4. May I place it in the question? The dispute between the parties relates to gratuity, provident fund, family pension, and other allowances, but this court, while issuing notice to the respondents, confined the dispute only to the family pension. We would therefore deal with the question of family pension only. Family pension rules 1964 provide for sanction of family pension to the survivors of the railway employee. Rule 801 provides that the family pension shall be granted to the widow, widower, and where there is no widow, widower, to the minor children of the railway servant who may have died while in service. Under the rules, son of the deceased is entitled to family pension until the age of 25 years. And unmarried daughter is also entitled to family pension till she attains the age of 25 years or gets married, whichever is earlier. The rules do not provide for relation of the deceased railway employee. The family pension scheme under the rules is designed to provide relief to the widow and children by way of compensation for untimely death of the deceased employee. The rules do not provide for any nomination with regard to family pension. Here also there is no provision for nomination. Instead, the rules designate the person who are entitled to receive family pension. Thus, no other person except those designated under the rules are entitled to receive family pension. The family pension scheme confers monetary benefit on the wife and the children of the deceased railway employee, but the employee has no title to it. The employee has no control over the family pension as he is not required to make any contribution to it. The family pension scheme is in the nature of welfare scheme framed by the railway administration to provide relief to widow and minor children for the deceased employee. Since the rule do not provide for nomination of any person by the deceased employee during his lifetime for the payment of family pension, he has no title to the same. Therefore, it does not form part of his estate, enabling him to dispose of the same by testamentary disposition. Hereby making nomination. In the present case, it is by testamentary disposition, but in the present writ petition, my lord, it is by way of making nomination, as they have stated in their affidavit. Whereas the particular regulation, pension regulation, do not provide for nomination. Only to fill up the form for pension, recording the name of the wife.
That's all.
My lord, the one further point that in spite of notice to the wife in the writ petition, writ proceeding, she chose not to appear and not to file an affidavit. My lord, here, my lord, the doctrine of non-traverse is applicable because she was invited.
Doctrine of non-traverse to dismissal of your claim. Yes, it is applicable. Why not? You are correct.
Non-traverse. on the-
Non-traverse leading to dismissal of your claim is applicable. It is not that your claim was allowed. Yes, what do you have to say?
My lord, being the respondent bank, we do not have any disliking or liking.
No, where is the provision for nomination? Just show us.
There is no provision, my lord. This is not a question of nomination. It is misleading. Why I say this, my lord, kindly see the page 58 of the appeal, my lord, stay application. Well, this is a form that which was required to be by the deceased employee.
Under which provision? That is what we are asking you.
My lord, can you see? He has named Meera Shapoi as his wife, not nomination.
Under which provision we are asking you
My
for the third time?
Can you see this policy, my lord? The State Bank of India Employees Pension Fund Rules. Rule 23, my lord, at page 10, my lord. State Bank of India. This. Rule 23, sub rule 5, my lord. Regulation? No, regulation. It is rules, fund rules, not regulation. My lord, page 10. My lord has got, my lord. In the event of death of a member while in service of the bank, after completion of pensionable service of 1 year, or after retirement, the trustees may sanction family pension to the dependents of the employee on the terms and conditions approved by the central board. My lord, pursuant to this, a regulation has been, my lord, pursuant to this regulation has been made out, my lord. My lord, kindly seize this. Family pension.
You are referring to page 10.
Page 10, my lord has got it. Page 10. Not exactly what my learned friend has shown earlier to my lord. But pursuant to that, my lord, this has been framed. This
No.
circular has been framed.
This is State Bank one that you have given.
Yes, we have State Bank.
Yes.
Respondent here is a State
So
Bank.
this is in this which provision you are relying on?
23.5. Rule 23.5, my lord, at page 10.
23.5, page 10 of the rule.
That's all right. So it is the same.
Pursuant to that, my lord,
Same.
this has been framed. This circular has been framed by. Kindly seize, my lord, page 5. My lord, some portions are marked, my lord. Kindly excuse me for that. At page 5 of this circular, my lord. Papers to be submitted to the PPG, my lord. Papers to be submitted to PPG department.
What is
Let the-
PPG? What is
means-
PPG?
Pension, my lord, pension and gratuity department.
PPG is Pension and Gratuity Department.
No, my lord.
How can it be?
Pension, Provident Fund and gratuity, my lord, department. Annexure 1A. Declaration of family members and dates of birth duly signed by the applicant and the bank manager. My lord, pursuant to this application, which is annexed to page 58 of the appeal, was filed, my lord, by the deceased employee. We are not supposed to know how many wives he is having, whether he has a second wife or third wife. We are not supposed to know. The declaration, what he has given, that yes, Dolly Shapu is my wife and such person is my son. So we are bound by that declaration, my lord.
And where is that declaration?
At page 58, my lord, can you see? He has not stated nominee. Nowhere nominee or my testamentary successor, nothing of that sort. Clearly stated as my wife and son.
Where is that? Which
At
clause?
column 11, my lord, can you see? Column 11, particulars of the family members to whom the family pension is payable. Family members, not nominee. Not my successor, testamentary successor or like that. Particulars of the family members to whom the family pension is payable now or afterwards. Part declaration of Meera Shapui, wife, Dharmendra Kumar Shapui, son. We are not a civil court to judge who is the actual wife, who is not.
You have not challenged the second marriage.
Lord, I have not as such. No, in no forum we have not.
And what is his date of demise?
Date of demise, my lord, date of death, DOD. My lord, 17th October 2019. 17th October 2019.
And second wife is appearing.
No, man.
No.
Never mind.
What do you want? Tell us.
My lord, may I, my lord, serve the private respondent again and come back so that your lordships can take her version by any supporting document.
At the outset, you said that it is no non-traverse. Now she cannot say anything.
No, my lord, non-traverse, I have stated, my lord, undoubtedly, I have
Yes.
stated. Because that is, from her side, there is no denial. She
If
did not.
she is here, at least we can ask her whether she is willing to share something or not, because both are wives and both are children, as per your submission.
Right.
Otherwise, there is nothing. You cannot. You find the prima facie that the Honorable Single Judge order does not require any. They cannot be faulted for what they have been doing or what they have done. But if she is present, we can see if
Yeah, I appreciate that they cannot be faulted, but on the basis of the
third learned advocate for the
এক সেকেন্ড স্টিচ করা নেই সরি স্টিচ করে 17th করে দিন নাকি 17 15 হ্যাঁ 15 Okay.
Item number 7.
ওইটা নিয়েছিস
State of West Bengal matters. After holiday. After holiday. None appears for either the party.
Number 8.
Your opinion.
Several occasions they are seeking adjournment. They are not interested. I think that.
They are not seeking adjournment today. They have not appeared. None appears for the
Item number 9.
Lord, I am for the petition. My lord, state cannot be represented possibly, my lord. The difficulty is, I am also suffering, my lord.
there is none to represent the state.
Item number 10.
Number 10 and 11, I'm appearing for the principal accountants led by HON'BLE.
What is your role?
For my role, sir, I will, your lordship, I will disburse the money.
Huh?
Disburse the money, just the execution authority.
So it is consequential only.
So, execution.
None appears for the
Item number 11.
Your lordship, I am appearing before the principal accountant.
same
Same matter.
same order.
Grateful, your lordship.
Item number 12.
Well, my lord, I for the petition, my lord. I prefer short passover, my lord.
Hmm?
I prefer short passover, my lord. My senior is engaged in a matter before courtroom.
Not today. Party. Not today, just. Oh, state of state. None appears for either parties. Item number 14. Teen. Hey, और बाहर काम कर रहा same or 16.
On earlier occasion, state and commission was directed to file their opposition, my lord.
But commission is not intended to file opposition since the allegation is not against the commission.
State
It
has
is
also
purely
not
a
filed its opposition.
promotional matter, lordship. Commission has nothing to do with this matter. State is
You have
the
only a consultative process. In promotion, there is nothing, no role of the commission.
commission only, whatever the state government send the file and commission only approve the,
So consultation is there.
and all the allegations leveled against the state. Against that allegation, commission has nothing to say.
The state is unrepresented. Item number 17. You are for a counter.
18.
But I appeal for the petition, my lord. Understand, my
State.
lord? State, my lord. Mr. Mukherjee is supposed to place, my lord, the vigilance commissioners, that matter, my lord.
Keep it after the holidays. The state is unrepresented for all.
Thanks, June. 19.
None appears for the parties.
Currently, I am praying not today, my lord, on behalf of the petitioner, my lord.
You are praying for?
Not today, my lord.
All right.
Just only now.
51.
For the petitioner,
Yes.
my lordship, short passable, my lordship. My senior is
Not today, madam. No short pass.
my stop.
22.
Them are parties.
23.
No, I put the petition. Yes.
Compulsory dependent manner. My father died on 30th April 2011.
On
30th April 2011.
11.
Thereafter, my lord, I filed an application for compulsory payment on 5th July 2011. Thereafter, my inquiry committee was held in 2013. My lord,
Rejected.
no, my inquiry committee directed to consider that. My lord,
Three member inquiry committee.
yes, thereafter, my lord, it was pending, my lord, that was not considered, my lord. In 2016, my lord, I filed an application before the tribunal, my lord, in 2016. And then, my lord, after filing the, my lord, application, my lord, again an inquiry was held. There, my lord, my PR was
2016 OA is what is the number of OA?
my lord, OA 817 of 2016. Lord, I challenge that order, my lord.
Of 2000 of 817.
Yes.
What was the direction in OA 817?
There is an inquiry again held, my lord, during the pendency of this. And there, my lord, my PR was rejected on the ground that the total family income of the deceased is more than 90% of the gross monthly salary drawn by the deceased employee. That is the reason, my lord. My lord,
So that order was placed before the tribunal.
yes, my lord.
And the
And tribunal also, my lord, I affirmed that order, my lord, and rejected my claim.
So you came.
I have come.
That is the order you have challenged.
Yes.
What is the date of the order passed?
My lord, date of the order is, my lord, impugned order, my lord.
Oh, that is the impugned order.
Sir, 17 January 2024.
What is the date of rejection by the authorities?
By the authority, my lord, Lord, 3rd February 2021.
3rd February
2021.
22.
21. During the pendency of this application. February.
You are relying upon some Supreme Court judgment. Yes. Some Verma's case. Where is that judgment? Huh? Where it said that family pension is not to be included. That is your case. How that will apply to your case?
Another thing, my lord, kindly see, my lord.
Yes.
While rejecting, my lord, the authority has relied.
Which page? Which page? Where is the rejection order of 3rd February 21? Your son?
Yes.
And earlier your mother had also applied.
I am applied. I am the one of the son, my lord. There is two son, my lord.
So earlier another son had applied.
No. Then the son is applied.
No, there is a rejection of 2013.
2013 inquiry committee has, my lord, commented, but
The inquiry committee has found that the family income of your mother is more than 90% of the last pay of Mr. Swench. So you are disqualified in 13 on itself. The report has been sent to the authority. That is correct. See page 22.
Before that, Malord, kindly see. Malord, kindly see, however, third paragraph, page 20.
Please read.
However, during inquiry, the wife of the ex-guard of that he was under the
Pressure to maintain her family. So we are recommending it. But they have held that the income is more than 90%. That is a finding in the inquiry report. So how it can be granted? That will be contrary to clause 6 of the 251 EMP.
Malord, kindly see, Malord, my father died in 2011. They are relying upon the Malord notification of 2013 and 2016, Malord. Kindly see, Malord. At that point of time, Malord, my income was not like that. And another thing, Malord, kindly see.
So what was the applicable provision in 2011? Which was the applicable provision?
2008.
2008. That's why we are asking you. That says 80% only. Even less.
But Malord, kindly see.
The subsequent provision is to your benefit.
But Malord, kindly see, Malord, one thing. While Malord, while calculating the income of the family, Malord, they have considered the interest. They have considered the interest of my mother's family pensions. That is included.
So therefore your ground is that family pension cannot be included.
Malord, here what is family pension my mother is getting, and my mother was a family teacher. She's also getting a pension. That pension and his Malord interest is also calculated in this family. I can show, Malord. Malord, kindly consider this, Malord. After Malord, this 21's order, deduction order was passed, the learned tribunal directed me to Malord file a supplementary. I filed that agree, Malord. From 25, Malord, I have the supplementary affidavit, Malord, filed, Malord. Kindly see there, Malord, I have exhaustively, Malord, stated everything. It started from page 25. They are also, Malord, relying upon judgment of Malord, Honorable Justice Bosak, Malord. They are also
All the income, see ultimately what all has to be included while calculating the income of the family to ascertain whether it is above 80% or 90%. That is not left to the discretion of the authority. What components have to be taken into consideration is specified in the EMP. So which parameter has been included which was not there in the EMP? That is all that you have to tell us. According to EMP, what was not to be included? The pension being which the wife was receiving, that is not to be added.
no, Malord. Kindly see page 21 once. Malord,
Yes.
bottom question, Malord. The calculation of late Mohammed Muzaffar Hussain, Malord, that is the family pension.
Huh?
But Malord, kindly see page 21.
Yes, we are looking.
Question, Malord, the calculation is given. Calculation of Mohammed Muzaffar Hussain, that is the employee. Basic pension is this, Malord. This relief 52%, Malord. That is the interest, it is included over here, Malord. That was from the Malord, my what I have get in and due to my pension other benefits, Malord. That interest is also calculated.
Where is the interest?
That is the add interest this, and this is the Malord calculation of baby act. This is the wife of the deceased Malord. His pension this, and this interest also, Malord, that was included.
We are not asking what was included. We are asking what has been included, which is not to be included as per the policy. You show us from the policy which has wrongly been included. We know that all these things have been included. There is no dispute because it is in the inquiry report. So which one of these component has wrongly been included to calculate your family income to assess whether you are entitled to a compassionate appointment or not? which component has been included, which is not to be included. Because we find that it is stated in clause 6 of 26 EMP. The entire thing is stated what is to be included and what is not to be included. Before the tribunal, you said you are relying upon the apex court judgment. That judgment we have considered in one case. Therefore, we know it is the judgment passed in some Verma petitioner. In that case, the rule said that the monthly income from the family pension was not to be included for ascertaining the penury. In here, the rule says everything is to be included. The monthly income, family pension, interest,
I think come to,
from movable, immovable property, everything is to be included.
page 36 of my 36 madam. But I have stated, my lord, while filing this affidavit, my lord, supplementary affidavit, the above
The amount has been spent by you, that does not mean it doesn't have to be included. That is no ground that I have already spent it. Has to abide by the scheme.
at the time of death of the employee, it was 35% and it was not 52%. Well, kindly see page 37, madam.
36.
Page 37, madam. I have start from 36, madam. Calculation. The above calculation is full of erroneous entries as interest comes when the principal is in the account. The amount received as DCRD amount of deceased employee had been spent subsequently by the widow of the employee for the purpose of studies of his son. Furthermore, DCRD amount of the deceased.
Did you raise this ground before them?
Yes, sir.
Where is that? Show us.
Well, the supplementary affidavit is filed.
Where? Which page? Oh, this is a supplementary affidavit.
After the rejection order, the tribunal has directed me to file the supplementary affidavit. I have filed the supplementary.
Then how the tribunal has considered this supplementary affidavit? Let us see.
They are also, my lord, everything I have, that was not considered.
So if the dearness allowance is reduced from 52 to 35 month, what will be the monthly income?
It will be less than, my lord.
And how the last month's salary is relevant?
I have stated, my lord.
Sir, please come to clause 6 of the 26 EMP. The last salary is not relevant. What salary and dearness allowance he was getting last, that is not relevant. What is relevant is the family income right now after his demise.
But they have, my lord, rejected on the ground that this is the 90% of the gross monthly salary drawn by the. That's why
How this is relevant? What the husband was getting is not relevant.
that is the reason they have rejected me.
No, that's not the reason.
Kindly see, my lord.
That is not the reason. They have rejected because total family pension, family income is above 90%, not because the husband was getting more than 90%.
Kindly see, income is falls below 90% of the salary last drawn by the. That is the reason they have. They have calculated, and as because it is 90% of the last salary of the deceased mother, that's why they have.
See, if we have understood correctly, what you are saying is instead of 90% of X, they have calculated 90% of Y. Because the dearness allowance which my husband was getting was less. Then you will be in more trouble. It will cost 95%. If his salary was less, then 90% will be lesser. Yes. We can understand if you were saying that no, he got more salary, so this is not 90%, this is less than 90%. You are saying he was getting less salary because instead of 52% DA, he was only getting 35% DA. So if that is a situation, then if the salary decreases, then 90% will, the amount will be increase more than 90% of the lesser salary.
Calculate that person, my lord.
Hmm.
My lord, page 37 and C, my lord. They would on my copy. 37 B and C, my lord. The annual relief at the time of death of the employee was 35%, it was not 52%. The respondent calculate the same wrongly, purposely, and motivatedly in a qualified intent. After deducting 70% of the annual billing, the amount would stand only 16093, which is again much below than the deceased employee's last month's salary. And the C was that on the day of death of employee, that is group D employee, the self of the employee was only released in the year 2014. And at that time, 2011, my mother was not getting pension. If the self pension of the into of the journalist will be deducted immediately after the date of the employee from 2000 something, it will stand to 7838 per month. Whereas the last salary of the deceased employee was 17866, which has no relevancy with the alleged calculation tendency of tendered by the respondent authority in their.
Father died in 2011. So at that time, your mother was getting salary.
Because in fact, that is true, my lord. I cannot say anything. But at that time, my lord, he has not.
She got salary till 2014. Then you got family pension of your father. Your mother was getting her own pension. Till 3 years after his death, she was getting her salary. How it can be below 90%? Cannot be.
Correct that, my lord, my wife, my mother was, my lord, in service till 2014. My lord, my mother, my lord, retired on 31st January 2011. Here it was written, my lord. What is written, my lord?
31st January?
31st January 2011. My lord, because
Maybe, but she got her pension from 2014.
yes, that is
That we have seen, yes. But she was an employee,
yes, that is
so she was not dependent. The tribunal has gone into the issue of income, but this is available only for dependents. She had her own income and her own life. She is not dependent. So how the benefit can be extended to a person who is not dependent on the income of the deceased?
wife is not, my lord, applied for, my lord, of vice.
They are all sons are also not dependent on the father. They are dependent on the mother also. Just see the scheme. Dependent has been defined. Dependent family member means spouse, son, including so and so, so and so, so and so, who was wholly dependent on the government employee. Neither the wife nor the sons were wholly dependent, because both father and mother had an income. Therefore, they were disqualified under the scheme, irrespective of the income.
The income, my lord, at that point of time, my lord, was very less, my lord.
Hmm?
At that point of time, 2011.
And your mother was a teacher.
Yes, primary teacher.
So she must have been getting some good income. And father was grade 3.
No, group D.
Group D. So getting better something. There is no dependent. He has taken.
24,
Pink or not good.
not today. Yes. 5.
Lord, I appear for the petitioner. Lord, that Kolkata police constable recruitment, but state will not be a part.
Should we keep it after the holidays? For obvious reasons.
Like 26, beg to appear for the petitioner, my lord. Pleadings were, my lord, complete. State, my lord, state.
Same order.
Okay.
Seven.
इसमें ये नहीं किया or keep it on Monday. Keep it on Monday. Just on, give the date of Monday. Get 1 week, maybe some interim.
28.
28, my lord, I am for the petition.
No. Okay, sir.
Time for the petition. Last occasion, my lord, sir, please to direct the state to file evident opposition, but it's not.
No, you are supposed to file a reply.
No, they have not served any evident opposition. And my lord, in this matter, my lord, I am praying leave to file one supplementary affidavit. My lord, because my lord, this is a compassionate appointment matter. And after death of my mother, death of mother of the petitioner, my lord, petitioner applied for on the same date. Petitioner submitted 2 applications. One for family pension.
They have not granted you any leave to file a supplementary affidavit.
No, my lord. But I am praying leave.
When it is
My
taken
lord.
up, is it a document which was not before the tribunal?
My lord, before tribunal, I have already filed a supplementary affidavit.
This was there before the tribunal.
My lord.
Whatever you are trying to bring on record, are these facts already before the tribunal? Or
My lord.
let them, let us see. When it is taken up,
9th June. 9. 28.
আকাশটা হচ্ছে 18th।
of the petition I'm paying for not today. My lord, can it be let it be on after vacation, my lord?
Same order. For obvious reason. Some consent. That's right.
Yes. None appears on.
Actually, what they appearing for the petitioner, my lord, state have filed the affidavit opposition, my lord.
Filed it.
Perhaps, my lord, I have been instructed that the state had filed the opposition, my lord. We have to file reply, my lord.
They must have served you, but they have not filed. The learned advocate for the
To the petitioner, my lord, this is a matter relates to resignation of a doctor. No, my lord,
last week, let's see. We have already passed an order for instruction.
yes, my lord, your lordship is there, my lord. My client told me, my lord, I do not know the veracity of this of his. But he said, my lord, his case file has been sent to the vigilance. This must my client has intimated me, my lord. But with the veracity, my lord, I cannot comment anything on that, my lord.
Then nothing will happen in a week.
I understand, your lordship. I leave it to lordship.
After the holidays.
As a lordship.
The petition.
After it, not.
My lord, I am praying for not today. I am praying for not today.
Not today.
But I appeal for the petitioner, my lord. They have used their opposition, my lord. I made the affidavit reply ready and served, my lord.
Have they filed it? Let us see.
That I do not know, my lord.
No, they have not filed it.
Then keeping it, my lord.
What is it regarding?
Well, I want my suspension to be, my lord, reviewed and revoked. In 2017, a criminal case was there, my lord. I was placed under suspension. My lord, I confine myself to the prayer of my lord, my suspension is concerned. My lord, neither they have reviewed the suspension in terms of the government orders or the rules, my lord, which is there, nor my lord, they revoke the suspension even itself. Although in the criminal cases I got acquitted.
There is none to represent the
Thirty-five.
none appears for the part.
Thirty-six. I'm appearing on behalf of the petitioner, my lord. My lord, after my lord, state is involved, my lord, state is there. But my lord,
You have filed an application.
I have filed an application for substitution because after.
That's what we are asking. Where is it? CAN number?
CAN number is 1.
It's not here in the record.
My lord, I have served.
We are asking you when you have filed it. CAN 1 is on the list.
Of January. 21st of January, my lord, 2026. It has been filed.
Once it is called, you take 10 minutes. Going here.
To submit.
Nothing, sir. Tomorrow.
This case was very important, my lord.
Call the next case.
37.
37, I am for the petitioner. The last occasion, my lord, your lordship granted leave, my lord, to file a supplementary affidavit annexing, my lord, from 2021, my lord. No date was fixed, my lord. matter is pending from 2021, my lord. Because, my lord, no certified copy was produced before your lordship from after 20.
It is pending since 20.
No, bench is not available.
Where?
My lord, state administrative tribunal, my lord.
Since 21, there is no bench.
Yes, no. Kindly see, my lord, I have also.
21, there is no bench.
Bench was there, my lord, no hearing was take place, my lord. Kindly see, my lord, the reply of the register of the said court, my lord.
Forget about it. Let us see what is your prayer.
Prayer is that, my lord, only for my lord, my past service on the basis of the judgment, my lord, passed by this court, my lord, petitioners working for the said post, my lord, 1984, my lord. Regularization was made, my lord, in the year 1997 without affecting, my lord, considering that, my lord, the others were given, my lord, 1996, my lord, instead of 1996, they are given 1997. Petitioner retired from the service 2020, 18, my lord, 2018, my lord. Prayer is, my lord,
Where is OA? Where is copy of your OA?
yes, my lord, I have annexed, my lord. My lord, kindly come to, my lord, the page, my lord, 19, annexed P1, my lord. I annexed the service book also, my lord, of the petition in the
Page 90.
19, my lord, 19, my lord. From 2016, that is pending.
What is your date of retirement?
2018, January 2018, already retired from the service.
January?
January 2018, already.
Where
retired.
have you said this?
Yes, my lord, I have stated, my lord. Kindly come to the page 6, my lord. I have stated, my lord, January 2017. It was wrongly typed, my lord. It is January 2018, my lord. Page 6, my lord.
What is the date mentioned in your OA?
Oh, yeah.
How it can be 18? If it was 18, then you will be getting pension anyway.
Yes, I will get pension, my lord. But my lord, the effect my lord, only for instead of 97, it will be 96 because my lord, all are given my lord from the date of notification, the order by which my lord, petitioner is regularized my lord, in the year order passed in the year 1996. My
You
lord.
are getting pension.
Yes,
Then what difference it will make?
six, my lord, only 1 year difference.
So what is the difference?
Quantum of my lord,
Pension will increase.
yes, my lord, pension will be increased. Only that, my lord. Other nothing, my lord. Other getting pension, my lord.
So you want pension to be calculated from the date of?
From the date of
18/4/96 is
Yes,
date.
yes,
On that date, what happened?
on that by memo number 4182 of dated 12 April 1996, appointment of petitioner was regularized.
Which page?
Page 6, first page, first paragraph.
Where is that document? Which page is that document?
Document is not annexed on that this memo number. I mention page 6.
Show from the OA.
Kindly come to the page 24, running page 24, internal page 4.3, my lord. 4.3.
But you have joined on 18/4. Why?
Yes, my lord. My service book is there, my lord. Kindly see, my lord.
Why you joined on 18/4?
Casual basis, my lord.
Why you joined on 18/4? When notification was issued on 12/4, why did you join on 18/4?
They have affect the service from that period, my lord. 1984, my lord, they have petition.
You said the order for regularization was issued on 12th April 1996.
But my lord, it was affected. It was affected by they affected, my lord. I am not joined, my lord. I am continuously working, my lord. I am continually working, my lord. I am the casual worker, my lord.
Your own averment at page 24, see para 4.3. What? Yes, my lord.
So, my lord, on
Everything you are submitting in here.
that, on that, I'm.
Why we are asking you? Why did you join on 18/4? You are saying I did not join, and your client says he joined on 18/4.
Yes, my lord. But
You are making statement contrary to your client.
order was issued, my lord, 12 April. I joined, my lord, 18th April.
Why? Why you took so many 6 days to join? Why?
They have allowed me to on that day.
They would have allowed you to join after another 20 days. The point is why you delayed.
That is their discretion, my lord. They have allowed, my lord.
That is their discretion. What are you saying? Make some sense.
Previously, my lord, I casual, my lord.
12/4/96 they issue an order. You join on 18/4. Why after 6 days? You have not said anything. It is their discretion. They are good enough. They may allow you to join after another 15 days. How that is going against them?
That 6 days, I am not claiming, my lord. Only claiming.
So from where do you show that 12/4/96 gave effect from an earlier date? From where do you show this?
This is the memo number. My lord, that memo was.
Where have you said that the memo gives effect from to regularization from an earlier date?
Then my lord, file a supplementary.
No, not here. This is not your case before the tribunal. Why you will file a supplementary affidavit here? Anything we ask you, you will file a supplementary affidavit.
That, my lord, kindly.
Wonderful.
Kindly, my lord, 7 days time, my lord. 7 days time being, my lord.
No, we will not. You are making submissions contrary to the record. And you want to file a supplementary now to include it in the record. Wonderful submission.
Supplementary, my lord. I'm bringing some
We will
documents.
not grant you any time for any supplementary. Just show us how you substantiate your claim. Show us.
I claim from the 18th April, not from 4th April, not 12th April. I not claim from 12th April. I claim from 18th April.
18th April, they have not given you.
No.
From when they have given you?
They given instead of 1997. Kindly see the next paragraph, page 25. Page 90, 4.5.
They have given you the scale of 800 to 1265 with effect from 18,496.
No, they have
No.
effect from 1/5/1997.
Now come to page 36.
36.
Yes. Tell us when they have given you that scale from page 36. Tell us.
That is the 300 rupees, 300. That is a casual basis salary, my lord. It is effect, my lord. Kindly see, my
You see on the left side what it says. 800 to 1265 Khalasi. 18,496. So, and 800 is the beginning of the scale. So they have written 800 in the center of the page. What is wrong?
they have pension was calculated from 1997.
How do you know? When they have given you a salary from 18,496, how they can calculate a salary from 90? How do you know? How are you saying so? You can say anything you want, but we are saying, how are you saying so? The document you have annexed is contrary to what you are submitting. You have stated that you joined on 18,496. You have produced a document which shows that from 18,496 you have been placed in that pay scale. And you are saying I have been given from 97. Just because somebody has told you to say that. Where is the show us from the record? There's nothing. It's not 300. You are it is a misconception. This is 800. Because 800 is the beginning of the scale. From 800 to 1265. On that day you were placed in that scale. So 800 they have given you. And every month it will increase on the date of annual increment every year. You see on 1497 it has become 815. On 1498 it has become 830. Every year it is you are getting the increment. So from where you are saying, where have you said in the OA that that period has not been considered?
Page 24, paragraph 4.3,
Huh?
paragraph 24, page 24, my lord.
No, paragraph?
Page 24, my lord. 4.3, my lord. My lord,
Where is it say that it was given from 97?
no, my lord, sorry, 25, my lord. 4.6.
Yes. 25 is not 4.6.
Yes,
25 is 4.5.
4.5, sorry, 4.5. The applicant has been taken into consideration with effect from 1/5/97 instead of 18/4/1996. That is only my.
But this statement is not supported by the document. The document belies this statement. Your document, you have annexed it. It does not support this. So how we are to proceed on this basis? There is no basis for making such submission.
Yes, the next page is also next page.
Come to page 37, Lordship is correct. This is also your document. Appointed to the post of Khalasi in the scale of 800 to 1265 and joined the post on 18496. You are saying that they are not acknowledging these documents. All the documents show that it is from 96. Where is your pension payment order?
That order, after matter was filed 2026, 16 retired from service 2018. So pension payment order is not annexed. If your lordship desire, I bring the pension payment order.
So PPO, once you go through the PPO, this ambiguity will be cleared.
I go through the PPO and come to the lordship.
None appears for the parties.
I'm praying for not today, my lord, only.
All right.
40 is my matter relates to resignation of a doctor.
We have already directed to take instructions.
My lord, but other matters are also there, my lord. May I say, my lord, let this matter all be appear in the same day. In the list, other matters are also the same in orders to pass by your law. To take instruction.
You have not been communicated acceptance
No,
yet.
nothing.
After holidays.
It's not my, let this be after holidays. When other matters similarly matters, my lord, where your lordship has passed an order asking them to take instruction. My lord, those matters will also be placed in the same day, my lord. On any day your lordship may, for your lordship convenience. But there are at least another
15-6.
Another 6 matters are also there in the list, today's list.
Today.
Today's list, my lord.
15-6. There is none to represent the state respondents.
I appear for the respondent number 8.
My lord, I am for the petitioner led by Mr. Shukanto Chakraborty, my lord. My lord, in this matter,
Respondent number 8 is private respondent.
private.
No, he is the current block development officer of Chunditala. He was implemented in his personal capacity.
My lord, pursuant to my lord's directions, my lord, the state has filed their affidavit, my lord, served their affidavit on us, my lord, and we have also prepared, my lord, affidavit in reply, my lord. My lord, we can file our reply, my lord, but since
Only if it is if the opposition is filed, otherwise
opposition
served
is
but not filed.
not filed, my lord, since they are not appearing, my lord, I am ready with the affidavit in reply, my lord. My lord, may I submit one thing, my lord? I have prepared one supplementary affidavit, my lord. After filing this application, my lord, 2 show cause notices were issued on me, my lord, and I have replied to that, my lord. To bring on record, my lord, I have prepared one supplementary affidavit.
Why? What is the relevance?
My lord, this is a subsequent event, my lord. For that reason, my
We are
lord.
asking what is the relevance?
My lord,
How it
since-
is has any bearing on the claim pending in the
Yes, my lord, it has some
How?
bearing,
Tell
my
us.
lord. Since I have alleged, my lord, that I have been heckled, I have been threatened with dire consequences by the concerned video, my lord. I have prevented to discharge my duty officially. No duty was, my lord, handover. Charge was handover, my lord.
You are on which post?
Block welfare officer, my lord.
So he has the same video has issued another 2 show cause.
Yes, my lord. After filing this application and immediately after hearing of this matter, my lord.
So every
On
day
20
he submits another show cause. Why do you need to file it? There
Madam,
may be more by the time it is taken up on the next date. So you need not keep filing it. That
My lord, we have prepared. I leave it up to your lordship, my lord. If my lord so desires, I will file it, my lord. I have already served copy upon my learned friends, advocate on record, as well as upon the state, my lord. If my lord grants me liberty, I can file, my lord. Now I am ready with the reply, my lord. I can file it. But since there is affidavit of opposition is not on record, my lord. My lord, I belong to scheduled caste community, my lord. I have been abused in the name of my caste. I have undergone medical treatment, my lord, for a long period.
Where is the relief that you have claimed before the tribunal?
My lord, you find that
Page 43, my lord.
So which prayer is maintainable in a writ jurisdiction now?
My lord, to consider my representation for transfer, my lord. I have prayed for
That you have already foregone in the last order.
my lord, that
Now come to page 43. Which relief can be granted by the tribunal or the writ court? Whether relief C can be granted or whether relief D can be granted. 1 and 2 is already over in the last order.
my lord, my difficulty is this, my lord. I am not in a position, my lord, to discharge my duty at the present post.
Our difficulty is that we have a limited jurisdiction and you are here to assist us. Again, we are asking you how relief C can be granted by the tribunal or the writ court.
Well,
Tell us.
Well, since there is a representation pending before the authority.
Nothing. That transfer issue is over. In the last order, it concluded. Now come to relief C and D. How it can be granted?
My lord, in that event, my lord, may I pray for one thing, my
You
lord,
may
since
come after recess. Look up any judgment you want. How a writ
Praying for not to give up. For item number 42.
Why not? Last time also there is an adjournment. Why an adjournment is sought every day? Not today, tomorrow, keep it at tomorrow.
43. My lord, I appear on behalf of the petitioner, my lord. My lord, on the last occasion, was pleased to allow me the liberty to add the state as a party respondent. The state has been added as party respondents. So, however, my lord, PSC would be the answering respondent, but my lord, I am praying for an interim order that there are 635 vacant posts. 632 has been filled up. I have prayed for one post be kept vacant, my lord, till disposal of this application, my lord. Otherwise, the entire exercise would become infructuous.
Yes, make out a prima facie case. Show us that you have a prima facie case.
My lord, I had appeared for the post of junior engineer pursuant to the 2017 notification, where I was given 149 marks. However, the
49.33.
149.33.
Yes.
However, the cutoff was 151.33.
Correct.
I moved before the tribunal. The tribunal had ordered reevaluation of my answer scripts, and thereafter had directed the PSC to consider reevaluation. After much deliberation and a contempt notice to reevaluate, my lord, at page 26, the PSC has come up with the letter stating that my mark stands increased to 160 from 149, and I am eligible for recommendation. However, till date, they have not recommended my name anywhere. At page 26, my lord, fourth line from the bottom. PSC has considered my application, and
Where is the tribunal's order pursuant to which this revaluation was done?
my lord, it is at page 15. 15. My lord, the last paragraph, may I read it out, my lord? Therefore, with the above observation, it directs the respondent number 1 secretary of the commission to have to reevaluation of the answers given by the applicant for question numbers 1, 9, 65 and 94 be done by a different expert who had not evaluated these questions before. Such re-evaluation be completed within a period of 8 weeks from the date of communication of this order, and its outcome be communicated to the applicant within 2 weeks thereof.
Merit list published in 2019.
Yes, my lord. 22.
2019.
22, my lord. The order is dated 2/4/25.
The merit list published in 2019.
Yes, my lord. But it is still valid. There is no averment on behalf of
How can it be still valid? Cannot be.
My lord, they have not made any averments. Even, my lord, in the letter.
Where is the merit list?
26.
Where is the merit list?
My lord, it is at page 31.
Huh?
Page 31, my lord. The entire list. of 632 candidates. My lord, even in this list, the numbers obtained has not been made clear. Only names and their roll numbers are written. From page 31 till, my lord, page 45. The list is still valid, my lord. There are
You are in which category?
32 posts have
You
been
are in
filled up.
which category?
My lord, unreserved category.
Huh?
Unreserved.
Upon reevaluation, you have been found to be having how much marks?
From the revaluation, I have been found to be of 160, 160, at page 26. May I read it out, my lord, from the sixth line. Consequently, your marks in aggregate now stands as 160 instead of 149.33. Thereby, you seem to be eligible for recommendation.
This is the order of the tribunal, page?
Page 15.
Tribunal did not consider that it was an ongoing process. It did not direct for sending a recommendation. No consequential relief was granted by the tribunal. It only said to reevaluate. That's all. Probably because it's a 2017 recruitment process.
My lord,
19, the recommendation was made. Tribunal is passing an order
in 25.
8 years after the recruitment process and 7 years after the recommendation was made.
Even my lord, the PSC authorities have never said that the entire process is
We
completed.
don't know. We don't know.
Because my lord, the
There is
entire
nothing to show. There is nothing to show that there is still vacancy and that from this panel appointments are still being made.
my lord, 632 posts have been filled up. 3 posts are still vacant.
Maybe, but they are whether to be filled up from that recruitment process or not. That is the issue.
That my lord, it has been.
There may be 30 more posts vacant or 300. That's not the point. Whether vacancies exist, whether the panel exists or not, that is the point.
That my lord, they have written that the reported number of vacancies is 635. And this is the panel, out of which if we calculate 632 has
Where
got
is life of the panel specified?
my lord, till 1st of December, they do not say that this panel has lost its post. P7
It will
page
say something only after you make an assertion. Again and again we are asking you, you are trying to shift the onus on them. Show us from anything that the panel was subsisting in 25 when the tribunal passed the order.
my lord, I only have the communication from their end, nothing of which
So they have said that yes, we revise your
even
marks.
in December 2025, they do not say that the panel is defunct.
They need not say.
They need.
That's not an issue before them. Even the tribunal does not say that you recommend it if it is found that he was wrongly deprived.
It is only them who can still say that.
No, it is for you to say, nobody else. Unless you come out with a case, we cannot call upon them to dispel anything.
My lord, still the panel exists. It is as per
No, show that averment from your OA that the panel exists. Show that averment. Cannot, by no stretch of imagination. After 7 years, a panel cannot be, it would be otherwise contrary to Article 14 and 16. You know the law. So therefore, a re-evaluation 8 years after or 9 years or 7 years after the recruitment process, what can you get? It is a fait accompli. What can be done? Is there any averment in your current way that the panel subsisted when the tribunal passed the order?
in the current way, my lord.
And if you have not got any interim order prior to that, then what can be done, sir? Cannot be a reservoir for
I have only
perennial
relied
reservoir
upon
to
their
make a point.
communications. I have relied upon their communication stating that this they have still
That you have been given wrong number. That is all that they have stated. Nothing less, nothing more.
But my lord, they have stated that I am eligible for recommendation.
Correct. No, they say that you should have been recommended.
No, my lord, they have stated I am eligible for recommendation. That means it is still persisting. That is why.
No, that is perhaps a far-fetched submission. We are not willing to go that far.
My lord, they have stated that you seem to be eligible
Correct.
for recommendation with respect to the aggregate obtained in
Correct.
the category.
See, if a tribunal,
Examination
a
2017.
tribunal is directing 7-8 years after the recruitment process to reevaluate, they reevaluate it.
Well, they themselves have said that it is still persisting and I am eligible for recommendation as per 2017.
We are unable to read what you are trying to read into that document. What you are trying to read into that document, we are unable to read. The issue is whether you have made any assertion that the panel is subsisting and that any recommendation is being made from that panel.
Well,
if you have not made any assertion, there is no question of calling upon them to dispel any such.
well, it is their averment that it is still
That
persisting.
we have understood. That
Is
we have.
there ever meant that it is
Again and again you are saying subsisting. We are saying we are not able to read that from what you are reading. There is no such expression used anywhere. It only says that yes, you were wrongly given that number.
But my lord, if kindly, my lord,
What is your prayer in that way?
in the earlier way?
Yes.
My lord, for recommendation for revaluation.
So it was not given by the tribunal.
But my present way, my lord, I have thought for recommendation.
Cannot so late in the day that you know the law very well. Show us that we can do it today. You show us that we can do it today.
We relied upon page 26.
You show us the law that the court can issue a direction today, 8 years after the panel. You show us that even if it is revealed 8 years after the panel lapse, that yes, he was wrongly deprived, a direction can be issued. You show us.
Depending upon, I'm only harping upon page 26, my lord. There's no other document which I can rely upon.
We can't find any way.
Said that we are eligible for recommendation as per 2017.
You want to work on it or you don't want to work on it?
If my lord kindly allows us some time, we can rely.
Yes. Show some citation that regarding,
Kindly allows us some time.
because otherwise you have a good case. Therefore we are saying. Tomorrow?
Kindly allows us some time.
Tomorrow? Tomorrow?
No, my lord. Tomorrow, my lord, kindly allows us
Just
a week's time.
as prayed.
It be on Tuesday, she said.
It's coming on Tuesday.
Lordship.
They appear for the respondent number 1.
Who is the petitioner?
Petitioner is Taposh Kumar Roy.
No, who is the petitioner? Where state?
Administrative.
State matters we are adjourning. What can be done right?
Tribunal passed an order.
The,
WPST was filed by the state.
the state is unrepresented
Lordship after observing
for
certain-
obvious reasons.
Okay. 45. Item number 45 and 46, my lord, I'm praying for not today, my lord. 45, 46. We are appearing on behalf of few of the private respondents. 47. My lord, here for the petitioner, my lord. This matter was taken up by your lordship on the last occasion, my lord. And my lord, the eligibility of the application was challenged, my lord. Because, my lord, the learned administrative tribunal, my lord, has rejected our prayer since the rule was not challenged, my lord. My lord, part of the order, page 35.
You are for?
I'm for the PSC. Lordship, again, in this matter, Shravani Sarkar is appearing.
But we were humbly praying, my lord. My lord was of the opinion, my lord. We will file a fresh writ petition challenging we'll take fresh steps, my lord, challenging the rule before the original forum.
Before the?
For the original forum, my lord. Because my
Original
lord,
forum is not existing. You will have to go before the honorable single judge.
my lord, now since the original forum is not, we have to go before the.
So we'll allow you to withdraw with such liberty.
My lord.
The learned. No, but this issue regarding rule being not challenged, it's already decided by the tribunal. How we can reopen that issue?
Was not challenged, my lord. Subsequently, here, my lord, we are
That is a ground for refusing the relief. Then how we can allow it now? That's already a ground for refusing the relief. So how can it is considered that you did not chose not to challenge the rule? Then how it can be reopened now? We will not say anything about the rule. Learned advocate for the
challenged. 48.
49.
49, I appear for the petition. State is not here, my lord. The state has served us with a copy of the opposition, my lord.
Is it
I-
filed?
I don't think so.
When they have served a copy? Not filed.
I would like to take an extension to so that I can file my reply.
Unless they file opposition, what reply you will file?
That case, my lord. Fixes a date. my lord. Thank you. I'm grateful to you.
My lord, Mr. Kushal Chatterjee is appearing in this matter for the petitioners, my lord. He is engaged in courtroom number 16.
Not today. Call them. 51. Next.
I am appearing on in 51, your lordship was pleased to give us liberty to file a supplementary affidavit.
For?
For bringing up next we had made in the petition to substantiate.
Have you served?
I have served upon them on 20th of February 2026. Taken on the of February.
Let it come in the last week. You see, if you have served today, we don't know if someone will appear, they will say we don't have copies. None, same order. Let's see. Next.
Mr. Bag is appearing. He's praying for not today. Milord.
Item 57.
Appearing. Ready with my affidavit in reply. 57.
Same order 19.
Alright, in this matter, I am appearing on behalf of the petitioner, my lord. By given of the petitioner, my lord, the way application is pending for the long time. My lord, the petitioner is a retired man. Only petitioner filed the area pension. He worked there for a long time and 16 years. 16 years, my lord, no promotion was given. He challenged before the state administrative tribunal. State administrative tribunal, my lord, get the application against that, my lord, file the application, OA application. That OA application is still pending, my lord. Since, my lord, 2022, my lord. My lord, petitioner is a kidney patient, and also, my lord, he is, my lord, suffering. And also retirement. I have annexed, my lord, order sheet.
Where is 13/3/2020 order?
Order sheet I have, my lord.
Where is the order of the additional chief secretary dated 13/3/2020?
Uh, 17/8/2022. The application was admitted. However, next date is 26/9/2026. On 30/7/2024, the bench was not constituted, my lord. Only one administrative member was sitting. Due to that, my lord, matter was adjourned.
Yes.
Ask my lord, last order was evening. Thereafter, our date has been fixed on 26/9/2026. Last at present date.
Come to page 53.
I don't.
Come to page 53. Paragraph 7 and 8. What is wrong with the consideration in paragraph 7 and 8?
7 and 8.
What is wrong with that consideration?
I am not coming before your lordship for hearing these. Only my direction for hearing conclude the hearing as early as possible.
Cannot be granted right now. There is no tribunal. The limited prayer of the writ petitioner is for
Last occasion, your lordship directed my state respondent to submit a report, my lord, on the basis of the regarding my last annexure, my lord, my lord, kindly come to page, my lord, 56. That report is very much required, my lord. So, my lord, your lordship.
last week.
Yeah, 56.
Last week.
Page 56, my lord.
I'm led by senior counsel Mr. D.N. Rai. He, for some personal difficulty, has left for home, and I'm seeking a day's adjournment.
Not today.
My lord, for the petition, not ready with my affidavit in reply.
Affidavit?
Affidavit in reply.
Position is filed.
Not know whether I don't know.
Last week. 63. Next. Not today.
Matter, my lord, Mr. Evan Roy is appearing.
63.
Yes, madam.
Not today.
For I appear for the petitioner.
Yes.
Well, it is here in this case on the last occasion your lordship had directed it was wherein I challenged an order wherein the administrative tribunal has not granted my prayer for paying of the subsistence allowance since my suspension. I was suspended in 2019. They had paid suspension allowance for subsistence allowance for 3 months only, and thereafter since from January 2020 till date they have not paid the subsistence allowance. The lordship on the last occasion when it was heard on 11th of March.
Last week. 55. Next. 56.
I am appearing for the petitioner, my lord. Last occasion, lordship direction given to the respondent to file affidavit of opposition. But
They have served. Have they served any copy?
no.
Very well. After holidays. You are appearing in this. 67.
Five, not today, ma'am.
Wait till the last. Wait before writing.
I filed this application on behalf of the state, my lord, appellant. But I am not, my lord. I pray before your lordships for adjournment of 2 weeks so that new, my lord, lawyer may then they will do
Not for the parties.
Lordship, deeply obliged, my lord.
Right.
69. Next. 70. 71.
Direction was state respondents to file their evidence.
They have served after holidays.
The urgency in this petition is
Last week. 73. Call. 74.
Should I for the big PS?
Yes, call the next. 75. Yes, call the next. 76. Last week. What is the, there is any direction? If not, then let it come after the holidays. Regarding resignation. Let us just give us. If there is some urgency, then only we are keeping in the last week. Otherwise, it will be a futile exercise. Oh, yes. This last week. 77. 78.
78, my lord, I am for the Public Service Commission. Item number 78 are, my lord.
Next. 80. 81. 83. Yes, sir.
Since the
New case.
no, new case, no, so, my lord, this matter was heard previously on earlier occasion. My lord, this is regarding, my lord, challenging the, my lord, notification of Kolkata police, my lord. So Mr. Mukherjee is appearing in this matter, my lord.
There is a direction for opposition.
Opposition, yes.
Other side of the holidays.
83. Mr. Roy is appearing in this matter.